and a very warm welcome to Quadrant Chamber's annual Energy Disputes event after a 2-year gap due to, well, you know what. This is our first fully in-person event, and there isn't a Zoom camera in sight, so this really is going back to 2019 days. It's lovely to see you all here, and thank you for coming. Tonight's event is partnered with Herbert Smith Freehills, and we're very grateful to them for hosting us here in Exchange House. It's very nice to be back. And you'll also be very grateful to them later for the drinks and canopies which will be served, and we invite you to stay as long as you can for those. So, energy disputes in volatile times. Well, I don't think anybody can doubt that the world has experienced a number of seismic events since our last event in 2019. We've had the first true global pandemic, and the travails of COVID, from which we're all gingerly emerging, but which is still affecting certain places like China in a major way. Hot on the heels of coronavirus, I suppose the fourth horseman of the apocalypse, has come the first, with the devastating war of conquest in the Ukraine, with its tsunami-like ripple effects on the energy sector and global energy markets. And all of this in the energy space, building on and influencing in unforeseen ways the pre-existing groundswell and the push to green energy and decarbonisation with unprecedented new levels of demand. And that's a push made more challenging for big energy by ever more strident climate change activism, which has continued unabated despite pestilence and the challenge of war. So volatile times indeed, and this evening's session is going to focus on the most pressing issues facing those operating in the energy industry today, from spiking energy prices, it's always entertaining to watch it every day, resource shortages caused by war, the challenges of decarbonisation, climate change litigation, and shareholder activism. So our distinguished and expert panel tonight will be addressing the ways in which participants in the industry are dealing with the fallout from these events and reshaping our global energy network and infrastructure. Let me introduce them to you. First, we have James Baily, partner in Herbert Smith Freehills, and our kind host this evening. James will be known to most of you. He's a long-standing specialist in energy and natural resources. This is the bit where I quote from the directories, always good fun, just to watch people blush. Yes, he's twitching already, which is good. Described by the directories as incredibly technically gifted, strategic, tough, and shrewd. And I can certainly attest to that from having worked for him, but also against him, and the doyen of complicated oil and gas cases. Next, we're very lucky indeed to have as our guest speaker, Áine McCartney, Vice President of Legal Operations at the Nordex Group, one of the world's largest wind turbine manufacturers, powering green electricity generation across the world, and also acting as a project developer of wind farms in certain sectors of the market. So we have someone here this evening, and there will be a question and answer session, so they're all looking forward to that, who is at the cutting edge, or perhaps I should say in the front line of renewable issues. And I'm joined by two fellow energy specialists from Quadrant Chambers, with whom I've had the great pleasure of working closely on many energy matters. Chris Smith, over here, described by the directories as extremely bright and lucidly clear in exposition. Well, you'll be able to judge that for yourself. No challenge tonight, Chris. And then lastly, a punchy and skillful advocate, a compliment which I echo based on my last outing against him in the Court of Appeal, where I came a very creditable second. Over here is Gaurav Sharma, formerly Senior Legal Counsel with Shell, and then with the International Arbitration Specialist 3 Crowns, whom we were very lucky at Quadrant Chambers to be able to grab. When the directories say, with Gaurav, you know you're getting a specialist in the entire energy space, they are right. When I lead Gaurav, I sometimes don't know whether I'm leading him or whether he's leading me. So what is the shape of this evening's panel discussion? The discussion is going to revolve around 3 particular areas. First of all, of burning importance, volatility in today's energy markets. We're going to be looking at recent major events that have changed the economic landscape, from the legacy of COVID to the war in Ukraine, sanctions, and the way in which they've dramatically impacted on oil and gas prices. And our panelists are going to consider contractual issues and challenges, including price reviews, effective breach, liability caps, force majeure, frustration, and default events. That's what they tell me, and they tell me they're all going to do that within 10 minutes. So we'll have to time them and see whether they do so. Then we're going to move on to current challenges for renewable projects, the brave new future world, focusing on the in-house perspective and the challenges associated with new ventures in the renewable industry as it experiences tremendous growth in the face of ever-increasing demand, and as established operators also look to increase their expertise and involvement in wind, solar and other renewable projects. And we're going to end up with environmental, social and governance issues, ESG criteria and ESG policies, also an aspect of the new world, and the regulation of the future energy industry, examining how traditional energy and natural resource companies are likely to face, well, they're already facing them, I think, a proliferation of claims from all stakeholders in relation to environmental issues, human rights issues, in a world that is decarbonising and trying to create a level playing field socioeconomically for everybody. So let me kick off our debate with volatility in today's energy markets, and by asking Gaurav about the effects of volatility in the markets, which we're seeing due to a host of factors. Gaurav, you and I have been dealing with quite a lot of these in recent cases together. What are the big issues as you see them?
Well, that's a good question. The big issue is volatility. I think that's the main thing. Just make sure you can all hear me. It's volatility, and I don't think anybody here will be unfamiliar with the volatility that's been caused by the high energy prices across the world in everything we do. If we go to the pumps, those of you who drive cars, whether they're diesel, petrol cars, you'll all be directly aware of exactly how high the energy prices are by that barometer that you see of 180, 190 pence per litre every time you drive past BP or whatever it happens to be. So you can see it directly affecting the cost of energy with the raw product, but it also affects the cost of living. It's the manufacturing, the transportation costs, and the inflation that's caused by these price of goods going up also affects our lives and the lives of those around us and society generally. And that's when we can get the goods, because of course there are dramatic supply shortages that have been caused by all of these events as well. So there's this huge volatility where manufacturers and suppliers have been going out of business over the last couple of years, and nobody's been replacing them because there's just no commercial way in which that can be done. So the world has really changed. I think that's the biggest change that we've seen because of these energy prices. Now, you all know that. I think the interesting question for me is how we got here, and perhaps to reflect a little bit on where we're going when it comes to this sort of volatility that we're seeing. And as you say, Simon, I think the current situation is clearly the result of a couple of events in particular that have taken place over the last couple of years, COVID-19, of course, and the recent Russian invasion of Ukraine as well. And these are events that have had a global impact and affected oil and gas demand and availability everywhere. So how did we get here? Well, if we rewind a little bit to 2019, we lived in a relatively stable world, geopolitically speaking. Clearly, lots of things were going on that we didn't know, and we didn't know what the outcome was going to be. China, US, trade wars, sanctions, and we even had President Trump trying to broker world peace by meeting Kim Jong-il in North Korea in 2018 and 19. And of course, I'm joking a little bit when I say that, but it was a relatively stable and predictable environment that we lived in by comparison with the situation today. The price of energy, the Brent crude oil price in 2019 averaged $64 per barrel. So to put that in context, that's it's a predictable price level on the basis of which energy companies can operate. They can plan upstream business and downstream supply in a relatively predictable way, in a way that was relatively recognizable for the price of oil leading up to that in the 10 years leading up to that price in 2019. Then, of course, by the end of 2019, beginning of 20, we had the COVID global pandemic, which changed the way in which we work, in which we live. Industrialized world reduced its energy demands dramatically. And so oil and gas demand also dropped dramatically and prices went through the floor. You may all recall in April 2020, West Texas Intermediate, the WTI crude oil price going below $0 for a brief period. Think about that today. But at the time, analysts predicted that the price of crude oil was not going to go above $40, that was the new normal. I mean, how that seems today. But over the next 18 months that followed, from around the end of 2020 to the beginning of 2022, which I'll come to in a second, demand steadily went back up, where production of energy, oil and gas in particular, remained relatively low, controlled, as we know, by the producing companies and countries. And so prices steadily rose during that 18-month period or so, up to February 2022, where we had, of course, the Russian aggression in Ukraine. And that act of war, with that act of war came sanctions. And that, of course, meant that huge supply volumes were gone, or at least could not be relied upon or countered by buying companies and by countries that relied on the gas and rely on the gas around Western Europe and Europe generally. So supply went down. Demand remains high. It's still high today. And today, the price of Brent is at $122, which, of course, is twice what I just told you it was in 2019. So it's a huge change. And there's really no reason that I can see why that's going to come down anytime soon, if I'm honest with you. I'm not predicting anything. Don't make any bets on the basis of what I'm saying. But it's not that obvious why it's going to come down anytime soon, I have to say. Now, at the same time that all of that's happened, as you say, Simon, the world has been looking to decarbonize. The demand for renewable technologies and infrastructure has shot up. It's dramatically increased and it's accelerated. The demand has accelerated for two reasons. Firstly, due to the political desire to reduce dependence on Russia, of course, but also the resultant high oil and gas prices that we've seen as a result of these events. And Áine is much better placed to tell you about this and what it means for the renewable energy industry. So I won't go into the detail of that. I'll just say that the price volatility, as far as I've seen it and experienced it, has applied just as much in the renewable energy industry as it has in the more traditional oil and gas environment as well. So all of this has led to tension and upheaval across the globe. If you look in the US, oil production remains high. It's buoyed by skyrocketing prices. We've seen record shareholder payouts for producing companies, record revenues for shale production as well. And interestingly, the Biden administration is complaining that there isn't enough output. They're not saying there's not enough and we need to decarbonize. They're saying that as well, but there's effectively a demand for production to be increased on the basis of this accusation that producers are holding back production to keep prices high. I'm not going to comment on that. I don't know, but that's what's being said. In Europe, we see a similar story. We see, as I said, supply shortages, high demand. So we see sort of similar efforts to increase indigenous or local production. For example, new licenses being granted for exploration and production in the North Sea, and green lights being given to projects that had previously been shelved. And we also see, maybe not in this country, at least not yet, but in many parts of Europe, we see governmental support for fracking, shale production increasing. And that's all, of course, aimed at diversifying the energy portfolio and reducing dependence on Russia. In Asia, the big story, of course, is high demand, particularly from industry requiring natural gas, particularly in the form of imported LNG. So look, I think the big point is this is probably all stuff that's intimately familiar with your practices and everything you do, just as it is with mine. But the effects, I'm going to come on to the final bit of what I'm going to say here. It's the effect that all of this has on energy contracts has been huge. It's been seismic. And here's a small selection of the issues that I've certainly been grappling with over the last few months, and I'm sure you have too, starting with price reviews. Now, I'm not going to talk about the mechanics of clauses. I think Chris is going to talk about that a little bit in a minute. But I think the question that we all see in the long-term oil and gas contracts that we deal with are whether or not these events that we're talking about, whether these price fluctuations and the volatility are long-term or whether they're short-term spikes, and therefore whether there is access to a price revision or a price review in a contract. And of course, there's no global answer to that question. I can't give you an answer. It all depends on the contract that you have and what it includes and doesn't include. But that's probably the key issue. It's a bit different from perhaps 10 years ago when we were looking at global movements from gas pricing, from oil pricing to gas pricing, etc. Now, I think it has to be dealt with on a contract by contract basis. Another issue, contractual flexibility. Oil and gas volumes, especially again in long-term contracts, often provide for the ability to flex up and down in terms of how much a seller might require a buyer to take. take more perhaps when the price is low in the market, take less when it's high. On the other hand, if you look at LNG long-term contracts, then you have flexibility for the buyer, for example, in the form of diversion rights, diverting cargoes to places where the price is better than it would be in the local market. And I think the tension here again arises really when you see a change in patterns in the way that these options are exercised. And, one party or the other just doesn't like it. And so takes issue with it. And whether or not there's a legal liability really depends on a number of factors. It depends on the contract. But I think a thing to look out for here is the governing law of the contract, because if you've got an English law or common law governed contract, it may well be the case that you've got the totality of rights all contained in one place, whereas in many other differently governed contracts with civil law governing clauses, for example, you may well find that the surrounding circumstances in which these options are being exercised is relevant and needs to be taken account of. And so that presents a very different complexion. Final thing that I'll mention that I'm sure, again, we've all been seeing is termination. People looking to exit contracts, whether by sale or by looking at other things, contractual mechanisms like force majeure, like default. And, it's often one or the other. A lot at stake when you rely on these things and decide to terminate a contract. So you really need to get it right. But, sanctions play a huge part here. That's the sort of thing that might trigger this debate as to whether there's a default, whether there's been a force majeure situation. Is it illegal to perform the contract now? Will banks refuse to make payments under the contracts and therefore make it impossible to make payment? Demands for payments in rubles. Again, I'm sure a lot of us have been having to deal with that. Is that a contractual amendment? Is it permitted under the contract, under the governing law? Big questions. And you probably get consequential questions that arise in relation to credit support, guarantees, and defaults there as well. So look, I'll stop there. Because I think, Chris, you were going to look at some of these clauses in a bit more detail, price review clauses and other clauses.
Well, we've been hearing from Gaurav about the effect of global events, price movements, impediments to performance. But Chris, in one sense, these are problems which contractually have been contemplated and covered in existing contracts, although the causes of these may be new. Are existing contract mechanisms coping? Price review, force majeure clauses?
Well, I think that remains to be seen. But what we do know is that they're being used. So because of the market volatility that Gaurav referred to, a lot of parties in the energy supply industry are seeking to rely on the price review clauses that they have in their contracts. Now, I'm going to consider a few of the nuts and bolts of such clauses just to give you an idea of the kind of issues that might arise. A couple of caveats. Firstly, not all energy supply contracts have price review clauses. Short-term ones won't. It's only really in long-term energy supply contracts. And the second caveat, and obviously, every single clause is different, and a lot will turn on the individual wording of the clause you have before you. However, there are broad similarities between all the clauses, so we can make some general points as to the kind of issues that will arise in the specific context of the volatility we're now facing. Right, so your common or garden price review clause, it has a few characteristics normally. Firstly, there will be periodic reviews. These are reviews that would happen within every 3, or maybe in Asian LNG contracts, 5 years of the contract. Each party will have, after that period of time, the right to send a notice saying, I want a price review. In addition to that, there are other types of price review clauses. These are called sometimes wildcard clauses, or jokers, or special triggers. These can be exercised by the parties over a very limited number of times during the life of the contract in the face of extraordinary events. What these clauses provide, and these are both types of clauses, is that a price review won't happen automatically. It's to be initiated by a party serving a notice. Now, a valid notice can only be served if certain triggering events or triggering requirements contained in the clause itself have happened. That's something I'll come back to. But if a valid notice is served, then what these clauses normally provide is that there will then be a period of negotiation. It's specified in the contract, normally not more than 6 months, and the parties will attempt to agree a price review. And if they can't agree it, well, I'll come on to say what normally happens in those scenarios. But firstly, let's have a look at the triggering requirements in a bit more detail. As I say, every contractual clause is different, but there tends to be some general themes to these. An Asian LNG contract that I was looking at recently had the following triggering events. Firstly, had the market conditions changed during the relevant time in the relevant market? Second triggering condition, and these are all cumulative, they all had to be satisfied, whether those changes have had lasting effects and are not merely temporary in nature. Thirdly, whether those changes affected the market value of the gas. Now, for periodic price reviews, the ones happening every 3 or 5 years, you don't need to show unforeseeability. The 3 events you've referred to can have been foreseen. That's not normally the case with the wildcard or special triggers. What, however, for all types of review normally needs to be shown is that there must be changes that are beyond the control of the parties, which is something I'll come back to. That's a kind of standard wording of an Asian LNG price review clause. In the case of Gas Natural and Atlantic LNG, this was a New York case, and this was a rare peek behind the curtain. Very few price review disputes come out in the open. They're all dealt with in arbitration, they're all confidential, and you don't get to see the terms. This was one where the New York courts did have to review the decision of a panel of arbitrators in a price review dispute, and so we got to see the clause. And the clause in that case had 2 requirements. Firstly, economic circumstances in Spain must have substantially changed compared to what was reasonably expected when the contract was entered into. And secondly, the contract price does not reflect the value of natural gas in the buyer's end-user market. So those are the kind of triggering events you're going to come across, and obviously there's always going to be, if there's a dispute about these clauses, an issue as to whether or not the triggering events are being satisfied. In the kind of circumstances we're dealing with in the market now, the volatility is obviously exceptional, it will have had an effect on the user price, blah, blah, blah. Normally you would think in today's events, the triggering requirements may well have been satisfied. Now, as I mentioned earlier, once you've served a valid notice, there's then to be a period of negotiation. What happens if that period of negotiation doesn't bear fruit? Well, usually the clauses go one of 2 ways. They either say that actually then the parties can refer the dispute to an expert for determination, or they can refer it to an arbitrator for determination. And the clauses may also say how the expert or the arbitrator has to decide these matters, either by saying in quite vague terms what's just and equitable, or more specifically, saying that they have to conduct the review by reference to certain specified indices. Obvious point, those fallback provisions as to what is going to happen if the parties can't reach agreement, they're necessary, because otherwise price review clauses would arguably be just agreements to agree. You have to have something in place to what happens if the parties can't agree. Going back to the Gas Natural case, that does provide a note of warning to any party who in the current climate wants to trigger its price review clause. In that case, the relevant tribunal in New York went off and went completely off-piste. It didn't do what either party had asked it to do. Instead, it adopted this quite novel dual pricing formula depending on where the cargoes were going. And the effect of the decision in that case was that Atlantic, the party that had served the notice and asked for the price review, ended up on the wrong end of it. And the estimates were the decision was going to cost it somewhere between 500 million and $1 billion as a result of having reviewed it. Unsurprisingly, that's why they sought to challenge what the arbitrators did and went to the New York courts. And because I think the reason the challenge got through the similar gateways or thresholds that they have in New York for arbitration challenges is because the arbitrators had gone off piece. So I think that enabled them to get it before a court, and that's why we have a public judgment. But the clause was quite a vague one. It said whatever is just and equitable. And the New York court ruled that the arbitrators had acted within the realm of their powers, and therefore their decision was upheld. So be careful what you wish for. Those are price review clauses. The other clauses I'm going to talk about are going to be quite brief. Force majeure in this context. The reason I'm going to be brief is, what with COVID and now Ukraine, I suspect force majeure is a topic that has been flogged to death over these last 2 years. So I'm going to be slightly careful here and not outstay my welcome. But instead, what I'm going to try and do is just illustrate some of the problems that come as a result of the interaction between force majeure clauses with price review clauses and other clauses in contracts of this sort. Generally speaking, most force majeure provisions, or a lot of them at least, require performance to have been prevented by the force majeure event. And there's a long line of English authority that says if a contract simply becomes more expensive, less profitable, blah, 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 it's not being prevented. So those kind of force majeure clauses aren't going to help you potentially in this kind of market. However, a lot of the clauses are wider than that, and they use terms as well as prevented, impeded, performance being curtailed, so on and so forth. And so that's the kind of broader clause that you can seek to pray and aid. Now, assume you have a clause like that, and assume that the volatility we have in the market is capable of constituting a force majeure event. What's the position where the relevant event itself also triggers the right to a price review under the contract? Does the fact that the buyer or seller could call for a price review preclude the application of the force majeure clause? Arguably, yes. Force majeure clauses normally provide that the events or the consequences complained of must be beyond the party's control. If they have a price review remedy they can pursue, it might be said the consequences they're complaining of are not beyond their control. Chris, but what about the scenario where the party exercised its right to the price review a couple of years ago? It didn't anticipate which way the market was going, and so it's already exercised it, and it's run out of rights. Or if, say, the last review was 2 years ago, and there's not going to be another review for 3 years. Does the fact that the party has played its joker already, or played its wild card, mean that it's stuck? The parties agreed that you have certain rights to change the price, and anything in between those, no matter what happens, you're just stuck with the price. Again, I think there has to be a decent argument that you might be stuck in that scenario. What if, take a slightly different fact, there's no right to call for a price review because the relevant market occurrences don't constitute a triggering event within the confines of the clause? Can it be argued that in such a scenario, as the parties have deliberately decided that the market occurrences don't entitle you to a price review, then a fortiori, they can't entitle you to be relieved of performance pursuant to a force majeure clause? Again, arguably yes. So as we can see, force majeure clauses in this context have to be read in context with the other rights and provisions that exist under contracts of this. I mean, there's other ones I could have mentioned, such as downward flexibility clauses, so that give you the right to kind of like alter the contractual quantities you're required to take. But when asking, has performance been impeded by events beyond control, you have to look at what other rights there are under the contract. Final point, before I'm just going to hand over, just on force majeure provisions, notification clauses. Everyone who's relying on a force majeure provision must remember that there's always some sort of requirement to give notice to the other side of the relevant event. And it's quite remarkable over the last few years how many conversations I, and doubtless many other of you, have had with clients who think, well, because it's COVID or because it's Ukraine, everyone knows that. I don't have to give notice of events that everyone knows about. It's not like, oh, so-and-so's mine's flooded, but that's not in the public domain yet. And many people think they don't need to comply with the notification clause if it's something that the other side's aware of. Well, maybe. It all depends on the wording of the clause. But if the wording of the clause says you have to provide notice of the event, and if you do not, you cannot rely on the force majeure provision, well, then more fool you if you don't do that.
Yeah, I mean, I think that's a very, very salutary warning. I mean, I've got about 3 things on at the moment where it's obviously a force majeure event, it's obviously within the clause, but there are issues about, is the notification provision a condition precedent to the ability to invoke force majeure, and what's the effect of it? And there are some pretty red faces on various sides of the equation. Before we leave volatility, can I bring you in, James and Áine, on this? James, you, I know, specialise in disputes involving long-term LNG and gas contracts. How are market volatility aspects impacting upon that particular type of contract?
I'm just going to be a little bit circumspect in identifiers. But look, as Gaurav and Chris have said, I have no doubt lots of you are involved in price reviews at the moment. We saw a lot of price reviews featuring COVID, particularly in the context of Asia, with a review period of 2017 to 2021. They are sort of coming through in the mix now. And I suspect we will therefore see it as that was when demand was depressed. Now prices are rising. I suspect we will see a new wave of price reviews. It will obviously depend on the extent to which price rises post the Ukraine situation are sustained. But the reasons Gaurav says, I don't see any reason why they're not going to be sustained. I think there is an interesting dynamic where you have oil index contracts, as you still do see in a lot of long-term LNG and gas sales agreements, where as the high oil prices feed through to the contract prices, some of the pressure in the balloon will be let out. Because you're seeing sellers at the moment who may be triggering, because they're saying the end user market prices have gone up so much, we want a piece of that. There needs to be a rebalancing of the profits, the sharing of the contract. But as the contract prices go up, because the oil prices, which will lag in how they're expressed, contract prices go up, then some of that pressure may come out. So it'll be interesting to see how that plays. I think there will be wildcard reviews potentially in other more novel mechanisms under some of these long-term contracts. Sonatrach of Algeria, who contract under Algerian law, I think it's well known, served bouleversement notices on more or less their entire portfolio of buyers, with one or two notable exceptions. I'm not quite sure why. Essentially, these are sort of a form of hardship clause, and essentially saying, look, end user prices have gone up hugely. Therefore, our buyers are able to make more money in their end user market, and we want a piece of that action. It ignored the fact for a hardship clause, this strikes me as difficult, that the oil prices were going up at the same time. They were oil index prices. Their costs of production weren't going up at all. In fact, Sonatrach's profits should have been going up the whole way through, but they were relying on a hardship concept, albeit under Algerian law, to trigger. So you will see, I think, sellers being quite inventive about how they can claw back what they perceive as value. And frankly, it's unclear when necessarily a lot of buyers will be making increased margins down the line. It depends on hedging and things like that over the short term. And I think the last point I would make is this. There was a lot of talk a few years ago about how long-term LNG and gas sales agreements are relational contracts of the type that Justice Leggett was, and I'm saying got very keen on.
Very keen on.
And whether this is one sort of a prime example, long-term contracts required a degree of cooperation between buyers and sellers as performance. But I think that is correct. There are, to a certain extent, accepted principles of risk sharing between buyers and sellers. But price volatility will mean that those relationships will get tested. But I think where your contracts are governed by English law with the importance of certainty, you would hope that the background may be some quite extreme price volatility will not affect the way in which those contracts are interpreted. And my experience is that that's not the case. And in a couple of cases which have come to the courts on this, I think that is the approach. We've seen a very orthodox approach. And to a certain extent, courts having regard to accepted principles within the industry of how a risk should be.
Yeah, and that's been my experience too, of how the court is coming away a bit from the more extreme margins of what I can call the Leggett relational theory, but nevertheless feeding in what an industry practice is, against which the parties can be taken to at least objectively to have been contracting. And before we leave volatility, Áine, in your sector, in the renewables sector, what are the issues caused by volatility? Is it different there? Are people insisting upon strict contractual rights, or is there a more holistic, cooperative approach?
It is absolutely different from what I hear tonight, at least. We work in a very volatile industry already. Yeah. And before the issues that we've experienced in the last 2 years, it was already very changeable. And of course, what we are experiencing now with COVID and then with Ukraine has led to even more volatility in our market. And we particularly see volatility in steel, commodities, shipping, all of these issues, which of course you read about all the time in the press, affect us hugely. These have an immediate impact on our projects, our sourcing. Of course, they lead to delay, which also impacts the projects, and it makes a huge difference to our industry. But what I do see is that these are, and certainly in Nordex, we have to approach these in a practical, pragmatic way. We cannot treat these as legal issues alone. And that's partly because we don't have price review clauses generally in onshore wind. They are usually fixed price contracts. And that means that the questions that are immediately asked to the lawyers in Nordex, and I'm sure the other OEMs as well, are what do we do when the supplier comes to us with a 50% price increase against the terms of the contract, but that's what they want. Yeah. And what do we do to pass on those prices to our customers, despite the fact that we have a fixed price contract? And those are the kind of questions that we see. And I do see the appetite for risk changing, but at the moment, that's the challenge that we face.
Thanks very much. Before we leave volatility, Gaurav, I mean, looking ahead, if you take up the Gaurav Sharma crystal ball, usually pretty reliable, I think, at least in the cases I've led you in. What is the long-term impact of volatile pricing? Do we ride it out and come out the other end, or are things going to change forever?
I think the latter. I honestly do. I think that we're in a place now where, at least again from what I see, just purely based on what I see, I don't think it's a case of saying, well, who's going to survive? And let's just see how the industry shapes up. I think the reality is we're seeing huge projects and huge contracts coming to an end. And they're either coming to an end because people want to terminate them, or because people want to terminate them for political and strategic reasons, or because they're not profitable anymore, they're not commercially viable. So there's a whole host of projects that we probably all grown up with over the last sort of 5 or 10 years, possibly more, and know very well. But I suspect that in a year or two, when we look back, they just won't exist. Honestly, they just won't exist in the same way, because they'll have changed ownership, they'll have been dissolved, and they just simply won't be the projects that Europe, for example, needs when it comes to the supply of, gas or oil, or the sorts of contracts that are needed in China for gas production and LNG imports. So I honestly think that the world will look slightly unrecognizable in a year or two, the energy world.
Well, ladies and gentlemen, you heard it here first. If we take up one crystal ball and put that to one side and take up another crystal ball, and I think anybody will be able to predict that the future for renewables is, although maybe a volatile future, is a certain future. And so, Áine, I want to come back now to renewables and renewable projects and change focus to renewables from volatility issues. I mean, the energy sector faces an awful lot of challenges, but what are the current challenges that are facing your industry?
First of all, before I start, I want to say that, we're a room full of lawyers here. I'm going to try and avoid talking too much about force majeure and
you can't stop Chris talking about force majeure.
There may be some reference to force majeure in what I'm going to say, but I want to give some idea of the practical problems that we face, because as I said already, often these are not issues with a legal solution. And what I found interesting is the same week that I received the request to come and speak in this panel and talk about the challenges in onshore wind, the legal department at Nordex received a request from the business to answer what seemed like a very legal question. The situation was this: we have a number of projects in Ukraine, but we have one very close to Crimea, where we installed our turbines. That wind farm is now in occupied territory, and during the military action there, at least one of the turbines has been destroyed. So the question from the business was, what are our obligations under the turbine supply agreement? This is the current project which we're installing. And obviously we have warranty obligations, etc., that we need to abide by. And as a lawyer, it's very easy to pick up the contract, look at the clauses, We might look at our liability provisions, our warranty provisions, our force majeure provisions. And of course, we would check our caps on liability. We've heard a lot about force majeure, frustration, our other contractual rights that we might have, or obligations, in fact. But the answer to this problem is not straightforward, and it isn't really a legal one. And the reality of it and other situations like it are what we as a business have to deal with right now. Of course, making investments in any kind of energy infrastructure is not a quick process, and particularly in renewable energy, where the pressure to compete with conventional energy is constantly there. Or I've talked a little bit about cost of energy. And I mean, cost of energy is a phrase that we say every day in Nordex. It is so relevant to our business. I think we can all agree that the cost of renewable energy has to be realistic. But it also means that we and other OEMs in onshore wind, and I'm sure offshore wind as well, are under constant pressure to ensure that our supply chain is able to deliver an acceptable price. As some of you may have read, Nordex took the decision to close our blade manufacturing plant in northern Germany recently, due to the fact that the blades manufactured there are not competitive. So why are they not competitive? Is it because the German government doesn't give us sufficient support to our industry? Is it because employment rights in Germany mean that hiring staff there is simply more expensive than other places like India, where we have also a facility? Is it because market expects subsidy-free energy from renewable energy? And it pushes OEMs to have a global footprint for this reason. Of course, I would need probably 3 days of lecturing to even begin to answer these questions, so I won't attempt to go into them now. But what is important about this is the way the market is pushing OEMs and other renewable energy industries to make cost-efficient energy also has consequences on how we do that. We have blade manufacturing plants in Mexico, Brazil, India, which are all more competitive and able to deliver the larger blades, which are successful in the market. We also have other manufacturing facilities in Germany, Spain, US, and suppliers' factories in Turkey and China. Clearly, just like with other OEMs, we have a global footprint. But having a global footprint leads to issues. And these are particularly exacerbated by the current volatilities that we see in the market. In our business, and as the legal department, we have to deal with increasingly outside-the-box situations. I just want to give you some examples of these, of the topics that have crossed my desk or my team's desk in the last couple of months, because I think they give you an idea of the challenges that we face as an industry. So first of all, one that I've already hinted at, how do we ensure that we can purchase sufficient volumes of steel at the right price, and given the huge increases due to sanctions on Russian entities particularly? If the steel is more expensive, we need to look at passing these costs on to the customer. The contract with the customer is almost certainly signed before we purchase the steel. So are we justified in passing on those costs? Is there a steel indexing mechanism, for example? That would be a very nice to have situation, but it certainly doesn't exist in the majority of contracts. And what about the supply contract where the price is supposedly fixed, but the steel manufacturer wants a price increase anyway and comes with this position of, well, do you want it or not? We can perfectly well give it to one of your competitors. Another example. How do we mitigate delays caused by our suppliers' factories in India being shut down completely due to COVID outbreak there? Of course, we need to mitigate these, but we must, as a listed company and as a company with social responsibility, ensure the safety of our employees. We have to ensure the safety of our suppliers' employees. This is also a very important aspect to our business. And if we do mitigate, if we're able to mitigate, who bears those costs? Are we able to pass them up the line to the customer? Another example, everyone I'm sure will have read about the recent Shanghai lockdowns, very much impacted our business. We shipped nacelles from China, so immediately impacted our business. and I'm sure my colleagues will debate whether this is a force majeure or not, but when you write a notice to our customers saying, force majeure, guys, COVID, after 2 years of COVID, you can imagine their reaction. They are incredibly skeptical, and albeit that it may be legally correct, we have to convince the customer in the first place. And finally, another example, which is very topical right now, how do we ensure we have enough vessel capacity to ship our components around the world? We have a very agile supply chain, but those components then need to be shipped to where the projects are, often back to Europe. And what happens in a situation which has actually occurred, where the vessel owner is put on a sanctions list after our components have been loaded onto that vessel, and the port has already left? What do we do then? Because the customer is not interested in delay, extension of time, additional costs. Some of these questions and situations may cross your desks when they turn into a proper dispute. And they may ultimately even be in front of a court or an arbitral tribunal. And when that happens, hopefully very few of those cases will go there. But if that happens, we may have an answer to some of these questions, though I doubt it will be an easy one, and it will certainly take time to get there. These are the kind of situations, of course, that us lawyers love to talk about and debate what happens. But for a business, seeking a pragmatic and commercial solution can be the only realistic way forward. All of these issues occur in a market which imposes specific requirements on wind development, such as requiring that significant percentage of manufacturing is done in the country. We see this, for example, in Turkey. Turkey has a very high percentage of local content requirements. And it occurs in many other countries as well in the world. These kind of country-specific requirements are common and require significant investment by the OEMs so that they can be present in the market. It's the same market that sees contracting parties, especially customers, and I know we're going to come on to this in a minute, increasingly looking at contractors' performance on compliance issues, on sustainability, on health and safety, on human rights records, and quite rightly so. These are very important issues which we need as an industry to focus on. Typical questions that we see here are, have we done business with any sanctioned party? Reference to what I just said. Have we ensured our turbines have been built in compliance with all environmental laws that are relevant? And that could be ones in the US, even if the project is in, I don't know where, South Africa, could be ones in Europe. And the extent of this kind of provision can be huge. Do our facilities meet health and safety requirements of our customers, who often set standards from the EU or US jurisdictions from which they come, but these standards are not necessarily easy to achieve in the countries where we have facilities. These questions, of course, don't just apply to the Nordex Group, they also apply to our supply chain and any other contracting party that we have up or down the line. So it's a huge burden for us. We also need to think about measures that might be taken to protect a market such as the EU. Potential anti-dumping rules on importing our components from China could have a huge impact. I go back to the example of nacelles coming from China. What happens to our carefully planned supply chain if we suddenly have to add anti-dumping duties to those nacelles? That changes our pricing structure completely. Across all these issues are our own commitments to the market. As I mentioned, we're a listed company. We also have pledges on sustainability, on diversity and inclusion targets, and of course to our shareholders. We are also answerable to these questions that they may put to us. But it's not all negative. For me, as an in-house lawyer, this means...
let's see you smiling at last.
I can smile about it. It's an incredibly dynamic and inspiring environment. I mean, I've been at Nordex for 6 years and I've seen so many changes in the industry in that time. I would like to see Gaurav's attempt at a crystal ball on what's going to happen in wind next. But I mean, just some examples of the things that I've seen change in the time that I've been in Nordex. There have been, I think, 10 new turbine types in Nordex. which have been released to the market. I've seen the warranted life cycle of a wind turbine go from 20 years to 35 years. That's a huge improvement and gives us a lot of hope for the future, I think. I've seen new models for developing wind farms, such as IKEA's development of subsidy-free wind farms in Finland. This is some of the first of their kind. And some would argue it's the future of wind as well. And I've seen traditional energy companies like Shell joining the market. I think this is a huge change also in wind. So for sure, it keeps me busy, not always with questions that have a legal answer, but certainly challenging. And on that note, I thought, Gaurav, you've worked at Shell, haven't you? It would be great to hear your perspective on the challenges that we face in renewables.
Oh, well, let me guess about portfolio then, and speculate wildly about many things. I won't speak for Shell because I don't know specifically what they're doing, but if I put myself back in the position, at least when I was in that company, which is a traditional energy company, I think that the biggest challenges that they're likely to face when companies that are in the more traditional sectors move across to the renewable sector is probably practical. They're practical issues. I think the first is having a department, having a group of people. Where does that belong? Where does that sit within a traditional energy company? I don't think it's that obvious at all. Where does the revenue come in? Which balance sheet does it hit? And which business line? Where does it report to? All of these things I think need to be worked out. And they won't happen in one go. I think they'll happen in a few revisions, in my experience of how these companies are organized. And I think while that happens, while that's happening, there's a second practical issue as well, which is the personnel, actually the people who know how to do the contracting, who know what the contracts even look like and where to get them from, because you can't. I think there is a general view that energy companies, within the energy companies, they can just generate contracts out of nothing at all, out of no market practices. They can just apply things from joint operating agreements or whatever it happens to be and make something that works for the wind industry.
That'll be great for the lawyers.
Yeah, I think so. I think there'll be whole new teams that are required to do that. So they're practical issues, but of course the money is there, the cash is typically there, and the will is there to build these groups out. So that's I think hugely positive. I think we'll see that happening, but there'll be a lot of teething problems while traditional companies, I think, come into the wind sector and solar and other renewable and parts of the energy industry, and probably clash with the culture a little bit. I expect, but hopefully that won't be too dramatic. That's my prediction.
Another crystal ball.
Lots of predictions.
Áine, thank you very much indeed for that fascinating insight into the practical challenges at the front line in the new world of renewables. Absolutely fascinating. I mean, you actually sleep at night?
Very well.
Now, James, Áine, let's just change gear and change subject. Áine has touched on environmental, human rights issues that investors and others are requiring energy companies to comply with. And I mentioned ESG criteria at the beginning of this talk. And the Financial Times defines ESG criteria as the long overdue supply of a social conscience to the energy sector, which has long been lacking in one, which I think is perhaps a rather strident statement, but nevertheless, what is ESG and what are the leading protagonists who are looking for better compliance by the energy companies with human rights standards, particularly environmental standards? Where's it leading us?
Yes, look, I would brief because time is marching on, and I'll let you have the foresight to bring a glass of wine onto the table. But
I've spoken with Chris Smith and Gaurav before.
Look, my opening observation in response to that is that ESG is an incredibly broad term. It covers multiple different concepts, and there's a risk of it meaning different things to different people. But so far as the energy sector is concerned, and its environmental issues, which are perceived to be at the forefront and are specific, human rights issues, governance issues, importance of respecting communities cuts across lots of other sectors. But the extractives and mining really is up there as well. environmental issues at the fore, and within the energy sector, particularly climate change and wider energy transition issues. That's not to say, therefore, that there are other issues which don't come within the ESG umbrella that are relevant. I think in the time permitted, I will focus on climate change. In relation to climate change, I think there are two broad buckets of disputes risk, if I put it in those terms. Firstly, claims from NGOs and government entities relating to policy. Initially brought against governments, but increasingly now brought against private entities. And the initial claims were about policy and about a change in direction. And I'm thinking of fracking, Friends of the Earth against West of Shetland drilling, Heathrow runway. They were about saying to governments that you have got the policy wrong and there needs to be change. I think that is now no longer the case. That where NGOs and activists are the position they're taking increasingly, both against governments but now against private entities, is you are traveling in the right direction, but in relation to reduction of greenhouse gas emissions, you are not moving fast enough. I have a litigation partner in New York called Ben Rubenstein, who does a lot of work in this area. And his thing is, we're all pointing in the right direction, but you're not pedaling. And the NGOs are going to be taking it upon themselves to say to companies and to governments, you need to pedal faster. And then alongside that first bucket, second bucket, which are claims, sometimes now brought by governments and state entities, but also classes of claimants seeking damages, compensatory damages. And there, really outside the US, there has not been very much. There is one notable exception I can think of, which is this claim in relation to Peru brought against RWE in Germany, which the German courts have allowed to proceed. Climate change is necessarily a global issue, and there are different experiences around the world. I thought perhaps before we looked at the situation in the UK, it'd be worth doing a quick whistle-stop tour, as it were, around some of the other major jurisdictions. I will not deal with the claims in depth. A lot of them will be known to a lot of you, but just do a quick sort of survey. So in Europe, really the claim there that caught everybody's attention featuring Shell was the Emilia Defensi claim last May. It's subject to appeal, so to a certain extent, I don't think we need to go through the details, but it was significant, I think. It was the first time that a national court held a private company liable for compliance with the Paris Agreement goals. And that in itself was significant. It very much, though, turned on a Dutch law concept of an unwritten statutory duty of care. The decision was handed down within days of an activist hedge fund called Engine No. 1 succeeding in placing 3 directors on the main board of Exxon. And so it was considered at the time, it was more or less a year ago, something of, I think, high watermark in terms of pressurizing companies in the energy sector in particular to pedal faster, as Ben would say. Australia, very much a claimant-friendly jurisdiction in relation to class actions. There's been a lot of activity, again, principally by NGOs. There was a claim last year called Sharma versus the Minister of the Environment, where at first instance, the Australian government was held to owe a duty to the children of Australia in relation to a decision to extend a permit for a mine. That was, in fact, overturned. It was a federal court decision, went to the full federal court, which then overturned it. But at the time, that sent out an initial shockwave, and the pace there is continuing. There is a current claim called the Australasian Centre for Corporate Responsibility versus Santos, the oil company, which relates to greenwashing allegations. These are allegations where companies are exaggerating, misstating their green credentials. It focuses on 2 statements in Santos's 2020 annual report. First of which is that they are concentrating on clean energy sources, by which they meant gas. Gas, as we all know, is being highlighted as a transition fuel on the way to renewables. And a lot of people have interpreted that, or have a lot of oil companies have stated that to say that it is a clean fuel. And real issues have been taken with that in relation to greenwashing claims. The other was that they had a credible plan, that was their word, in relation to moving to net zero by 2040. But you looked at their short-term plan, and their emissions were going to be increasing over the next 5 years. And again, therefore, the ACCR said that that was not a realistic statement. US seen by far and away the largest number of claims. It's a mixture between the NGO policy change type claims and class actions. So there is the greenwashing, consumer deception type claims. They actually extend far beyond just the energy sector. Some of them turn on federal and state legislation protecting consumers. They are brought often by actually state regulators and state bodies, as well as by consumer classes. Shareholder claims have not been the principal focus of climate litigation there. There have been a few claims by shareholders. In particular, Exxon was singled out because it came to light that Exxon had been using a different internal cost of carbon to the external published cost of carbon. And that found a number of claims, but actually a couple of claims that went to trial in New York were dismissed. So the potential there for that to run is still unclear. But by far and away, the largest focus there have been mass tort, public nuisance type claims.
Nice old-fashioned cause of action.
Old-fashioned cause of action, but used in a novel way. Interestingly, a lot of municipalities on the seaboard, as you would imagine, so California, New York, Denver also brought a claim for slightly different reasons. They have all were subject to motions to dismiss and jurisdictional challenges at an early stage, in part because they were often brought in state court, and there was a question about whether federal legislation ousted them. There's a US Clean Air Act. The question was whether, therefore, this was a federal state issue. They went through the courts, through the federal appellate courts. I am told that the current move is to remit these back to state courts to deal with motions to dismiss as to whether they disclose a proper basis of claim. The big question there is whether any of them get through the motion to dismiss onto disclosure, discovery. Because I think then you get into the realms of what US mass tort lawyers would call the big tobacco playbook, which is once you get into companies' documents, you are looking to see whether the internal statements were different from the statements made publicly. And that can make for a very uncomfortable situation indeed. So I think that's the sort of my whistle-stop tour around the world.
And I think also crossing the US-Canadian border, we're seeing that sort of group of actions in the Canadian courts as well.
Absolutely. Yeah.
I think the recent one I was reading about was also suing on behalf of the unborn children, Jeunesse Canadienne, I think. And I think we can, it'll be interesting to see what's going to happen here about that. But it is interesting to see public nuisance being used. I mean, I remember when I was doing the Milford Haven oil spill, people were casting around for causes of action, and public nuisance offered all the solutions. It's a really unexplored tort. And I think in environmental terms, it's absolutely an interesting tort to follow. But that brings us on to the UK experience. Chris, we're running short. I can see lots of tongues hanging out. I haven't heard any corks popping, but I'm sure they are popping in the next door room. So could you give us a whistle-stop tour of where we are in England? It doesn't seem as though much is happening, although there is a Client Earth or...
Climate Earth, yes.
Climate Earth.
Yeah, there's a few activist claims going on. So as James is mentioning, kind of like people seeking judicial review, kind of various NGOs. I mean, only a few weeks ago, Mrs. Justice Cockrell threw out a claim by a group called Paid to Pollute, who was against the Oil and Gas Authority, saying that their updated strategy, which was published last September, was inconsistent with the net zero target. But that was thrown out. It's the kind of claim we are seeing, we're going to expect to see. The Climate Earth claim, or not claim yet, is an example of shareholder activism. Climate Earth are a shareholder of Shell, and they've announced formally that they intend to bring a claim against Shell's board of directors, for basically being in breach of their duties under sections 172 and 174 of the Companies Act to promote the best interest of the company and act with reasonable care and skill. That's going to be very difficult because, as I'm sure you all know, shareholder claims are that sort of derivative claims. You've got almost a two-stage permission process, one on paper where it's just you, then a full-blown permission hearing where the court has various tests it must apply under section 263. One of the questions you've got to ask is, could a person who was promoting the interest of the company, would they not seek to pursue this claim? If so, the court has to get the claim out. Equally, if the claim is based on an act or omission of the company that the company has now authorised or ratified, the court has to kick the claim out. So there's a lot of high barriers, but Climate Earth have announced, and maybe this is just to get a bit of publicity and they're not going to actually go forward with it, but they've announced that they are going to be bringing a claim of this nature. But those are the activism claims. There's also my favourite, the greenwashing claims.
Why your favourite?
So last year there was the Competitions and Markets Authority. They published a green claims code, which basically was saying to all these businesses, right, here are your obligations under consumer protection laws to the extent that you seek to promote your products or services by claiming that they're having a very positive environmental benefit. Because as part of this survey, they said that actually 40% of the adverts they looked at online were in breach of consumer protection laws or unlegal, and they unlawful. And they set out various requirements. Like one was businesses should not claim an environmental virtue out of something that is in fact a necessity anyway. Which reminds me of the American golfer Bobby Jones in the US Open 1925. He was in the final round addressing the ball, and the ball moved imperceptibly to everyone else but him. But he saw the ball move. And he caught a penalty stroke on himself, even though no one else had seen it. And he ended up losing the tournament by that one stroke. And afterwards, there were lots of people saying, oh my God, but that's amazing. What a great thing you did. What sportsmanship. He was having none of it. He said, you might as well praise a man for not robbing a bank. Well, it seems, according to the Green Claims Code, lots of businesses have been seeking to get praise for not robbing a bank, or at least the environmental equivalent of it. And so they're trying to stamp down on that. So those are the kind of claims, kind of like that I think we are seeing and are going to see a bit more of. And obviously, one other thing, Simon, to consider is the possibility of the kind of claim we've seen in Holland being brought here.
Yes, I mean, that sounds to me as the legal basis for Milieu de France claim is very Dutch-based. What do you think?
Yeah, no, I agree with you. The prospects of that sort of claim over here are very slim. It's very much a Dutch law concept. And the idea of a duty of care existing under English principles is, as I said, very unlikely. I think the other issue actually also, so far as these claims getting to the ground, claims for damages anyway, is causation issues.
Yeah.
Because these attribution theories whereby you look to attribute events by looking at historic emissions is very difficult. I mean, from a oil and gas producer point of view, they are not necessarily the emitters. They are the companies who may be producing hydrocarbons, and those sorts of causation problems, I think, English courts are going to be very slow. I mean, sometimes these things are policy led, but the implications for generally causation in other areas would be so large that I think that English courts will fight shy of this for a while.
Yeah, I think English tort law makes this sort of
Very
area difficult for broad-based tort claims, which might be why public nuisance is a better bet. Chris, you were touching on English cases, and just the last word. One thing where we have been seeing intervention by the English courts is in parent company liability, cases like Okpabi and others. A last word from you on that?
Yeah, well, so as I'm sure you all know, in Okpabi, the Supreme Court last year said that the claim could proceed, that it was arguable. And in fact, they gave 4 potential gateways for parent company liability in those kind of scenarios. And I'm not going to go into that too much because of time. But just the most recent update on Okpabi, a couple of months ago, the court was considering whether to make a group litigation order, a GLO order. And it was saying it can't do that yet because the issues haven't been clearly defined enough. And it said to the individual claimants in Okpabi, you have to go away And each individual claimant, you need to basically plead the specific damage that you say was caused by the specific spill. It's saying, well, okay, this is a big claim, but if you want to pursue it on an individual rather than a global basis, there can be no shortcuts here. And the judgment of the court said, yes, it is going to be very time consuming. It is going to be very difficult. But if you want it on an individual basis, that's what you've got to do. And in acknowledging that it's on an individual basis, one option is to pursue the claim on a global basis. But the courts have warned that's a very risky approach to take because of causation issues. If with this global loss, there is one cause that the defendant's not responsible for, then the entire claim will fail. So having been very encouraged by, or at least people who wish to pursue parent company claims, having been very encouraged last year by the Supreme Court in Oxford, the most recent court decision in that regard sounded a bit of a note of caution that these claims are actually very difficult.
Thank you very much. Well, ladies and gentlemen, I think our panel are able to withhold their thirst for a little bit longer. If anybody has any questions, I know we've rather overrun, but we did start late. So if anybody has any questions, we'd be delighted to take them. Question at the back. Thank you. Would you mind introducing yourself? And then the microphone's just coming and state who your question's to and what it is.
Hi, Sean Gibbs from Hanscom Intercontinental. It's a general question for the panel. Given the volatility, are you seeing any change in people's choices of governing law?
Right. We'll start left to right. Gaurav. We're usually the last to know. Let me start with James, actually.
Well, I was going to say you're asking a whole lot of litigators, which is we're at the wrong end of the process. But if I was to speak to my colleagues, look, one of the points I made was about the emphasis of certainty under English law, but also the extent to which judges will not get swayed by transient issues, market issues. And I think that all of that favours English law. And I can tell you from the little bit of, so I am advising a client currently one of these Algerian law contracts. And that is a very, very, from my perspective anyway, all sorts of reasons, a much more tricky prospect. So I think in volatile times, you want a system that takes an objective and predictable approach to contractual interpretation. So I'm voting English law.
Okay, well, in answer to your question, I in ill-considered aside to Áine, said, "You're always for English law, aren't you?" And I was told, absolutely not. Áine.
I mean, I'm obviously fully biased. I would love to see the contracts that we have under English law, but they're almost never under English law. We're a German company, so it's mainly German law, but very often it's the law of the country where we're building a project. But we have the 72 lawyers of Nordex have been debating this point quite a lot recently, because it is absolutely clear to us that there are certain jurisdictions that are more helpful where we need to argue frustration. Frustration arguments, of course, don't exist in Germany, but it is a codified right there that where it is impossible to continue with the contract, even for financial reasons, we potentially have the right under law to increase the contract price. So we do see a swing. There weren't many English law contracts anyway, but we definitely see a swing towards French law, Dutch law, German law already dominates because they're far more helpful, we see, than English law.
Yeah, I mean, that's interesting. I mean, I've been having discussions with an Austrian lawyer recently about a lot of recycling plants, and Austrian law follows the German law model, which is the hurdles we have to go through under English law to prove frustration. And it doesn't matter whether it's economically devastatingly effective. We leave the economics out of it. It's simply so anathema to an Austrian and a German lawyer because there's a statutory right, a codified right, that if the complete contractual substratum changes so that the deal is just simply no longer capable of being performed in the way in which it was, then the law steps in and says it doesn't need to be. So I think possibly that assumption, which I would also make, that you are where you are with English law, or at least you know where you are with English law on advising on frustration, which is fantastically difficult. And I don't know how many people you've been advising over the last 2 years about, can we say the contract's frustrated? Almost certainly not. And that's the one. It's almost like, has it been repudiated? Has it been renounced? No, probably hasn't been that either. That at least gives you that element of English certainty. Last words from Two counsel at either end?
No, but if anyone ever asked for my advice, I would say choose English law, but purely for selfish reasons.
Well, there's a slight element of not knowing any other law to recommend if you're an English lawyer, isn't there? Unless you're well versed as Áine is. So there we are. One last question, and then that takes up to 7:29.
It's Luke Harrison from Keaton Harrison. A follow-up question on the last question, actually, and it links into what you mentioned earlier about the good faith duty in relational contracts and that sort of thing. It strikes me that in these volatility disputes, there's going to need to be quite a lot of creative lawyering, particularly where there are English law contracts where certainty is very important. And to butcher a quote from Samuel Johnson, the implied term, which I think good faith is now a species of, is the last refuge of the rogue. And I just wondered whether you think that the implied term is going to provide a lot of answers to these thorny questions where people are trying to walk away from what perhaps the contract on its face says.
I'll give you a visual answer, and the other panelists can give their answer. I think implied term is usually the last resort of the desperate, I think, which is why in energy contracts, where you see express terms about good faith. So it's no longer an implied term. It is actually an express contractual obligation to act in good faith towards each other. James, what do you think?
Look, I totally agree. Former partner of this firm wrote an article a few years ago about whether there could be implied duties of good faith in relation to long-term gas sales agreements. He wasn't at the firm at the time, but I think the general view, and it was an interesting point. His point was that this is a great example of relational contracts of the type, and when Justice Legacy then was getting really keen on this sort of thing, well, why not? The answer is, sophisticated parties, fully termed, agreements to deal with all of these aspects. So I see no scope.
Yeah, I mean, why would you have an implied term for good faith in an energy contract when some energy contracts have an express term and others don't? It's a choice, as you say, by the identity. Áine, do you have a view on that? I mean, you will be dealing with more good faith concepts.
Absolutely. I mean, I'm fully biased. Whenever anyone says that to me, I'm always like, if it's not in the contract, forget about it. But my colleagues in Germany constantly remind me that this is not the correct approach under German law. Yeah. So absolutely.
Right, ladies and gentlemen, I think that's now 7:31. You've been very, very patient. Thank you very much indeed. I think some doors are going to open and we're going to be shown into at the back, we're going to be shown to a land of milk and honey. I hope definitely not milk and honey. Yeah. So may I ask you to do something really old-fashioned, which is something which is impossible to do effectively on a Zoom hearing or Zoom meeting, which is, can you put your hands together for our wonderful panelists? Thank you very much. And the last word you'll hear from me, at least through the microphone, is a very big thanks to you, James, and to Herbert Smith Freehills for organising this wonderful venue. It's been great to be partners with you for this event, and thank you very much indeed.